a lot of information gets illegally leaked. How is it that that information so often finds its way into the media? And what do media companies have to think about when deciding whether to publish it? The short answer is that the media isn't allowed to break the law. A reporter could think the best story in the world is on the other side of that fence, but they're still not allowed to break into a government facility to get it. But what if someone else does the illegal part? Can the media be punished for publishing illegally obtained information if it was obtained without their involvement? This is where things get tricky. In a famous case called Bart Nikki v. Vopper, a radio talk show host broadcast the contents of an illegal wiretap. Someone had recorded a phone conversation between two union negotiators and had slipped it to an anti-union activist, who in turn gave it to the radio station. Normally, it's illegal to publicize the contents of an illegal wiretap. The thought is that this adds to the initial wrong, and that the possibility of later publication might encourage people to snoop. The court did something interesting here. The radio station hadn't been involved in the wiretap, so it had clean hands. The court said this meant it was allowed to broadcast the recording, but two of the justices only agreed with that because the conversation was exceptionally newsworthy in their view. Specifically, one of the union officials had said they would go to their houses and blow off their front porches. This was probably just two union guys talking tough, but it looked like real news to some of the justices of the court. So, coming out of this case, it seems like the rule is as follows. If the person doing the publishing is also the person doing the intercepting, then the state can sanction the publisher, and frankly will. If the person doing the publishing was not involved in the interception, and if their hands are otherwise clean, then the state cannot sanction the publisher if the information is exceptionally newsworthy. This is a fine needle to thread. Sometimes you'll see publishers talk very tough about this kind of thing, and sometimes you'll see them get very nervous. This outcome comes from an explicit balancing of speech interests. There's a First Amendment harm in not protecting the privacy of phone conversations. People will not be as willing to talk on the phone. But there's also a First Amendment harm to preventing publication. The rule in Bart Nikki makes a fair bit of sense. It is hard to insist that a newspaper sit on exceptionally newsworthy information just because someone else did something wrong. But this isn't a license to wiretap, and some of the subsequent case law makes plain that leaking information all over the place is simply not going to be allowed. Even in Bart Nikki, the person who recorded the conversation could still have been sued, if anyone had been able to find them. Same with breaking an NDA. The newspaper might be fine, but that doesn't mean you will be. In particular, sharing information given to you as part of your government job, information given in confidence, is often going to be sanctionable. What I want you to take away from this conversation is the complexity that the First Amendment adds to the privacy story. Even a simple privacy rule, like you can't publish illegally obtained information, needs to have a First Amendment exception, if an extremely narrow one.